Hello friends, this is PP and welcome to another video on the channel Law for All. Now in this video we're going to be talking about the technicalities governing the statutory notice to be issued under section 138B of the Negotiable Instruments Act as against the drawer of the check for dishonor of the check before instituting criminal proceedings under section 138. Now as always, before proceeding into the video, I would like to mention that the content that you are seeing on your screens right now is from a book called Guide to Dishonor of Checks. Now the link to that book has been left by me in the description section of this video, so if you're interested, kindly do check that out to know more about the check dishonor law. Now, a statutory notice under section 138B is sine qua non, meaning that it is indispensable. A notice under section 138B has to be issued to the drawer of the check that has been dishonored, asking him to make payment within a period of 15 days from the receipt of the said notice, failing which a prosecution shall be commenced as against that person. So the notice under section 138 cannot be skipped. In fact, the precedent is that an offence is committed only when the drawer of the check receives the notice and fails to comply with the terms of the notice within a period of 15 days. That is, fails to make payment within a period of 15 days from the receipt of the notice. Now, an offence essentially is not committed when the check is dishonored itself. Dishonoring of a check is not an offence. Non-paying of the check amount even after receiving the notice, even after 15 days from the receipt of the notice, is an offence under the Negotiable Instruments Act. So therefore a notice is absolutely necessary. Prosecution cannot be commenced without giving a notice under section 15 of the Negotiable Instruments Act, otherwise the prosecution fails. Now, if a notice under section 15 is given and if the drawer of the check replies to the notice, either admitting or disputing the claim, but if the drawer of the check does not comply with the terms, as in if he does not pay the check amount within a period of 15 days from the receipt of the notice, then prosecution can be commenced. Now, simply because a notice has been replied to disputing the facts as regards the notice, or if a promise with regards to payment of the check amount is made within a period of 15 days but the same is not paid, then in that case also prosecution commences. So it is not that if the notice is replied to and more time is sought to make payment, and if that time is beyond the period of 15 days, then that can also be counted within the period of limitation. It is not, that is not the case. If the drawer of the check receives the notice and if it does not pay within a period of 15 days, notwithstanding what the contents of the reply to that said notice may be, the prosecution will have to be commenced within 30 days from after completion of that 15 days. That is, you have to give a notice. Say if you give the notice on the 1st of the month that you have to make payment within a period of 15 days, so on the 15th of that month the cause of action arises. Now from that 15 you get another additional 30 days to commence prosecution. So therefore you have to commence prosecution within a period of 15 days from the date, that is 15th. Otherwise, if it is delayed any further, then it goes beyond period of limitation. Now that is the first aspect that has to be contemplated. Now, secondly, what if the drawer of the notice receives the notice and replies to the notice saying that I am willing to make part payment, and he actually makes part payment within a period of 15 days? Then what happens to the notice? In such a case, even if part payment is made, an offence is still committed. The drawer of the check is not absolved from his liability from paying the entire amount. So if the drawer of the check which has been dishonored even agrees to pay say 99,999 out of the entire 1 lakh rupee check amount that he owes to the holder of the check in due course, then even then an offence is committed. Even if it does not pay the remaining 1 rupee, an offence is committed and prosecution can be commenced as against the drawer of the check. So that is another aspect. Now the aspect is regards mode of service. Now how is the notice required to be served, or how can the notice be served under the Negotiable Instruments Act? Now section 138 does not provide for any mode of service of the notice. There is no specific way that it has to be served through courier, or it has to be served through registered AD, or that it has to be sent by email or anything of that sort. So long as the notice is acknowledged by the opposite party, it can be served in whichever fashion. Now it can even be served personally, so long as the drawer of the check is willing to sign an acknowledgement receipt to that check. It is most often the case that the drawer is not ready and willing to give an acknowledgement, that the notice is usually sent by way of registered post, because post offices are governmental departments, and so therefore there is a certain amount of credibility that is associated with the department. So therefore generally notices are dispatched through the registered post. Now, proceeding further, uh, notice, of course, now a notice may be served in whichever fashion, but eventually the fact of the matter is that the law mandates that the notice has to be given in writing. So notice cannot be given orally. No evidence can be led as regards the notice being given, orally. Notice has to be given in writing. Now, the next comes is the period of 15 days. That is, the section 138B mandates that it has to be made within a period of 15 days. Now, generally, the convention is that in the notice itself it is stated that you have to make payment within a period of 15 days, failing which I shall be constrained to commence prosecution. Now, what if the instead of 15 days it is stated as 30 days, because previously it was within a period of 30 days, then by virtue of an amendment subsequently that the period of 30 days was reduced down to 15 days. So what if by accident the period is stated to be more than 15 days? In that case, the notice does not suffer from any deformity as such, because the precedent is that if it has to be paid within a period of 15 days from the receipt of the notice. So therefore, even if further time of say 30 days is given to the drawer of the check to make payment, after the moment the 15th day gets over and the 16th day begins, that is when the cause of action arises. So the complainant can immediately file for prosecution and need not even wait for the remaining 15 days. Now, what if the less number of days is stated in the notice? What if, say, an amount is paid within 10 days from the receipt to the notice is stated? Even in that case, the notice will not be faulty, because the 138B does not mandate you have to state in the notice that you have to pay within a period of 15 days. The law says that you have, if it does not pay within 15 days of the receipt to the notice. So therefore, the stating of the number of days within the notice within which it is to be complied is immaterial. In fact, it is not even required to be stated. So you may not even state that you have to make payment within a period of specific days. You can just say that a check has been dishonored and you're liable to pay me. That is all that is required to be stated. So that is another very important aspect. Now subsequently, another aspect also is, what if an interest is sought on the outstanding amount of the check? Will that make the notice illegal? If an interest is sought, even in such case the notice is not illegal. An interest also can be sought, but the same while prosecuting the drawer for recovery of that amount, and interest cannot be claimed per se. Of course, there are provisions under the Negotiable Instruments Act with regards to payment of compensation, but the interest as stated in the notice cannot be recovered. The interest will have to be given by the magistrate while finally deciding the the outcome of the matter. So now, whether if mentioning of the check number in the notice is necessary, now that is also another aspect that is important. The check number also need not even be stated in the notice, because the essential object behind giving notice is to intimate the opposite party as regards the dishonor of the check. That is all. So therefore, so long as the check can be sort of identified, the check dated so and so, drawn on so and so branch, drawn on so and so bank, amounting to rupees so and so, if all of that is stated and if the check can distinctly be identified, in such case it is all right. So the check number also need not be stated in the notice. So well, that is all that is it in this video that I have to share with you. Again, I would like to point out that the description to the book that I'm referring to is in the description section of the video. The link to the book that I'm referring to is in the description section of the video, so kindly do check that out if you're interested. Do give this video a huge thumbs up if you liked it. Kindly share it with your friends and subscribe to this channel for more such content. Until next time, this is PP saying bye. Have a good day.